Hello everybody. Sorry. Running a little late today. Hello. Yes, welcome. Welcome aboard. Oh, we got so much to talk about tonight. So much to talk about. Yes, I thought that would be appropriate. After this day, today's just been complete craziness. So, oh my goodness gracious. Yes, good to see you too. I've got one more document to go grab. I'll be right back. Okay, here we go. So, just as a friendly reminder, we'll get, oh, you love my sign? Yeah, I thought it appropriate for Monday. Oh my gosh, yes. Happy Monday, everybody. Yes, I wanted to just write out at the top, I will be talking about this jury demand question. So I will be looking into that. We'll talk about that a little bit here. But let me get everything straightened out. Wait, yes, no. Frank, that's so funny. All right, am I in frame? Okay, everybody. Another crazy day. I know, right? I know. Oh, you work fast food. Oh, you know the pain then. You know the pain. You know it. Oh my gosh. Nothing but respect for those workers working fast food. That is a tough job. Hello. Welcome, everybody. Welcome. Yes, I've got some updates on what has happened today. So I'll be taking you through that. And then I've got a few other little updates too to kind of go through. So lots of fun stuff to do. Okay. Whew, goodness. I'm so far behind today. Yikes. All right. Oh, thank you. Okay. Yes, well, welcome everybody. Welcome. Good to see you all. Thank you for joining me tonight. It's been a busy Monday. We had a lot of stuff going on. Slightly left. Here, let me move my camera a little bit. I had to redo my tripod. So let me get that sorted out. How is that? Is that better? Let's see how that is. Yes. I wanted to talk about this. I want to get us just to start. We'll talk about this jury demand. Okay, good. Excellent. Thank you so much. So yeah, cuts off slightly on the side. Which side? On the right hand side? Angle it towards the right slightly. How's that? Better? Yes. All right, am I too far left now, or am I too far right? Or am I okay now? Too far. Too far. Oh my gosh. Okay, hold on. Let's pull it up a little bit. All right. Here we go. Too far to the right. Go back. Okay, how's this? Is this okay? It's perfect? Okay. Oh, what would I do without you all to help me? Thank you. Nope, it's too far left. All right, here we go. Let me see, 1 more minute. This will be my final adjustment. All right, how's this? Is this better? Thank goodness you're not a photographer. True story. Still more left. All right, all right. Wait, hold on. Here we go. This will be my final angle. So, oh my gosh. Yes. Okay. All right, perfect. Okay. Yes. VC, help me. Am I lined up okay? I need help. It's much easier with my students in front of me. Okay, don't need to move it. Okay. Oh, y'all are cracking me up. All right, it's readable. All right, okay, excellent. A little to the left. Okay. There we go. Your left or my left? All right, how's that? Is that better? Once we get it set, I'll tape it down. Okay, that's fine. Leave it. All right, okay, so here we go. Oh my gosh, hilarious. Oh, thank you so much for your help. Oh my gosh. Okay, everybody, welcome aboard. So much going on today, so much. So very much. I wanted to start right out with this jury issue, right? So we'd been talking about this the last time, and we're able to find, thanks to VC, we were able to find this document. Now, in New York, I was looking up their rules of procedure. Once a notice of issue is filed, so this was filed July 31st, she has checked this box, trial without a jury. So defendant has to respond within 15 days after the service of the note of issue to ask for a trial. And if they're asking for a jury trial, they have to set out in their notice requesting a jury trial the reasons for that request. Now they can make the request and the judges will typically grant it, but they have to proactively make that request in New York if they want a jury trial in a civil case, right? So jury trials are not a constitutional guarantee. That piece of the amendment's not been incorporated to the states yet, a jury trial for civil cases. So actually, I think that's the 7th Amendment. Let me just double check on that. Let me see here. Pulling up the amendments because we got to make sure we get everything correct. Right. Okay, it's the 7th Amendment. All right. So a couple of our amendments don't apply to the states yet, right? So under the 7th Amendment, in suits at common law where there's a value in controversy, it shall exceed $20, back in the day, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So this sets out the jury trial for civil, but this is only applicable to the federal government. So unless your state's included an amendment like this in their state constitution, you do not have a right to a jury trial in civil court. So that's where that rule comes from. Who's going to tell him? Not me. Not me. I'm out. But it's the 7th Amendment. The 7th Amendment, the 3rd Amendment, a few different pieces here and there have not all been incorporated yet to the states. So this is because of the incorporation doctrine, and this is one of those pieces. So when she filed her notice of issue in New York, she had checked trial without a jury. He did not respond. His attorney did not respond within 15 days with that jury demand, and therefore there's no jury. So that's what happened there with the jury situation. So just clearing this up. Yes, I did not see any particular filing that said that had looked like there was a check mark. But on the other hand, there have been hundreds of filings, and I was not able to get through all of them. It's possible that, you have a form like this where you check boxes. This may be what they're referring to, is that after this notice of issue came in, maybe they didn't notice that it said trial without jury. So maybe his attorney just didn't notice. And so she didn't realize she needed to file a jury demand. So this is what I think they're talking about regarding checking a box. But I don't think he had to check a box. I think he had to do a demand for a jury. And that's under the procedural rules in New York. So I believe that's what's happened in this situation. Yeah, it's something huge to miss. Absolutely. He's in breach of the Seventh Amendment. No, he's not. But he thinks that he has a right to a jury, but he doesn't because of the Seventh Amendment. So, most people understand or believe that the full Bill of Rights apply to the states, and that's very common because, we don't really explain the incorporation doctrine very well. New Jersey parking lot owners, really? Oh dear. But yes, so the Seventh Amendment just means you do not have a right to a jury trial in the states. So at the federal level, you can demand it after a certain amount, but at the state level, you just have to proactively demand it. Every state's a little different. And in New York, it says once the prosecutor files a note of issue, you have 15 days then to respond to ask for that jury. So he did not do that. It was not filed properly. Again, they probably just didn't realize or didn't notice maybe that the trial without jury box was checked. So his attorney just did not file that demand within the 15 days, and therefore his request then would be waived. So you are automatically not given a jury trial unless you proactively reserve your jury for a civil case. So that's under the Seventh Amendment. Again, that is not incorporated to the states. It doesn't apply to the states. And so each state has their own set of rules regarding that. Yeah, it's a pretty big whoopsie. It's a pretty big way. I think it was purposefully done. It could be. I mean, this is, as the judges put it multiple times, this is a documents case, and he's absolutely right. And so a jury might not necessarily, be something that would be important. Yeah, this was the thing is, though, about this particular one, if you look at the docket, and I've got the whole docket from the day the complaint was done. I've got the whole entire New York docket pulled up here, and the complaint is September of 2022, and there are just hundreds and hundreds of filings. And there was only one filing, though, on July 31st, which is when this notice was done. So it wasn't really kind of buried with a whole bunch of other paperwork. I mean, there are plenty more things filed before and after, but on the 31st, this notice is, the big thing that was filed that day. So I really don't know what happened, but, this is clearly his attorney should have filed something. Yeah, this is the only thing. There's something filed on July 27th and then August 1st, but this is the only thing that was filed July 31st was this notice of issue. And so again, he had until August 15th to request a jury. He did not, and so he waived his right to a jury in this particular case. Yeah. Again, and that's under the rules. That's procedural rules. Can this be grounds for an appeal with Trump claiming counsel incompetence? No. Just again, and that's under the rules. That's procedural rules. Can this be grounds for an appeal with Trump claiming counsel incompetence? No. Just by counsel, not asking process. So, yep. Yeah, so 80% of the trial's over because of the statute of limitations. Right. So I wanted to talk about that. So let me move this out of the way here for a minute, everybody. Trump did a quick post court day press conference, right? So within the press conference, let me just make sure. Am I in again? I'm just making sure I'm in view here. So let's talk about it. After the trial during today, right? No cameras were allowed. So they had opening statements and they had one witness. Now the deal, okay, we're in frame. Great. So the deal was he came out afterwards and he said a couple of things. First, he said he had wanted a trial and he was mad because he didn't get it, or he wanted a jury trial, but he couldn't get it. And that's because, again, they didn't follow the procedures in New York. So he's not allowed to have a jury trial because they just didn't follow the procedures. The other thing he said was the judge had made a comment in the last 20 minutes of the hearing regarding the statute of limitations. issue, right? So the best I can figure from my research is that there was some discussion about the different charges in here are from 2011 forward. And so the judge was kind of, maybe being a little bit more sympathetic to moving that date from 2011 to 2014 and beyond. So there's about a 3-year period of time where certain documents and so on would not necessarily be considered as part of the evidence. But that's not an official order at this point. It's not been put in yet. Yes, that's not been put in yet. And even if the judge, for some reason, if the judge says, I'm not going to accept documents from 2011, just after 2014, it wouldn't affect the case. So I heard what he said, that this would, change 80% of the case. That's just incorrect, first of all. And second, it's just a matter of a couple of years worth of documents versus all of the rest of the years where they have all the other documents. And I'm going to take you through the original complaint along with this opinion, the highlights again, and I'll explain what he's talking about. Again, we don't have an order, so this is just based off of this press conference he gave right afterwards, but we do not have any kind of backup order stating that he actually has decided to not allow that evidence in for 2011 and 12 and 13. So that has not been officially done, but even if he does, it would not affect his order at all, and it would probably not really affect the case either because there's so much evidence that came in after 2014. So those couple of years isn't going to make that big of a difference, but he made it sound differently when he spoke to the press. So I think that's something to really take a note of. So those were the two big issues he said post testimony today after his civil case had gone. So yes, lots of trolls. We'll just ignore them, right? You just take away their oxygen, the fire goes out. So those were the two big issues that came up in the New York case today. And I think it was very interesting. Yeah, the 80%. Yeah, and I understand what he's talking about, and I'm going to take you through the counts 2 through 7 that everyone's been talking about. I have the original counts, so we'll take a look at those so you know exactly what his trial in New York is about. But it is a bench trial. He did not demand a jury, which was required, and so he is only allowed to have a bench trial at this point. So, yeah, Kristen. Oh, yes. All right, missed the press conference. Brief summary. Yeah, he did too. He did one this morning, and then he did one after the day's, proceedings. And this morning it was very inflammatory. It was a campaign speech, more like he was addressing a political opponent rather than the justice system, the legal system, and the judge that, has earned their right to some kind of respect. Just this particular judge, I think, has been on the bench over 20 years. I mean, he's a senior, seasoned judge. He knows what he's doing. He's done a million cases like this before. So he's seen it all before. And so there were some derogatory comments that Trump had made before he went into court. So afterwards, he came back out saying he felt the judge had made a good ruling regarding the statute of limitations issue, which I don't think he fully understood. And then this demand for a jury, he had said, which of course you have a right to a jury only in criminal cases, not in civil cases. And the last thing he said was, jury trial, and then the, hold on, I just lost my train of thought. I got dibs. That's so funny. That's funny. Yes. So, yep. So that's the summary. So I will take you through. I did print out again so we could kind of go through this. I did print out the original petition. So I want to take you through the counts that are actually in question. So I will be taking you through that so that you have some idea of what the rest of the counts are that are actually in trial right now, because count 1 has been taken care of in this order, which I will go through with the highlights again. But the rest of the counts contained in the complaint are the ones that are on trial. So those are the ones we'll be taking care of. So I will go ahead and do that. But before I dive too far in, let me give you a little update on the U.S. Supreme Court. Yes, I said it, the U.S. Supreme Court. So we had two decisions, two orders that came down from the U.S. Supreme Court today. Today was their first day in court, and two significant decisions came down. The first one was regarding Mr. Eastman. Mr. Eastman had been asked for the January 6th committee. He was supposed to have done a lot more than what he did. Also, there were some emails that had been given over to the committee. He contested that. So he had actually had a writ of certiorari on file to the U.S. Supreme Court regarding this question of the information given to the January 6th committee, right? So today, the U.S. Supreme Court denied his writ of certiorari. Now, what's important here is that Justice Thomas recused himself. There were some questions of in some of the emails stating, hey, as long as we can get this in front of Justice Thomas, we're going to be good to go. And that seems to have been a theme repeatedly on a lot of the things going on in Georgia and some of the other cases. But this is showing us right out of the gate, Justice Thomas recusing himself, I think, is showing a trend for any of these other kinds of appeals that are going to try to go up to the U.S. Supreme Court. If this is a sign he recused himself off of John Eastman's case, he could very well recuse himself from any of the other questions that get brought up. So he recused himself out of the decision to deny cert, which was fine. He didn't state his reasons, but I think it's a really big sign of what's going on. Yeah, there's huge ethical questions going on. So, I think he's finally at a point now where it's like, let's not even put this appearance of impropriety into question. So he recused himself, and then Eastman's cert was denied. So that was a big order that came out from the U.S. Supreme Court today. So that was really important. Yeah, I think Chief Justice Roberts probably had a little say in that. Now, the second significant thing out of the U.S. Supreme Court was, hold on here, this case right here. Now, I'd spoken a little bit before. This is Castro v. Trump. Now, the reason this case is so important, this was that first case filed in Florida. Now, Mr. Castro is a Republican candidate for president, and he had brought a suit against Trump under the 14th Amendment, Section 3, right, that we've all been talking about. So he brought it, and he said that Trump should be disqualified. And the Florida court had tossed out the case, and he had appealed. So he put his writ of certiorari in front of the U.S. Supreme Court to decide this issue on whether or not Donald Trump would be disqualified under the 14th Amendment, and they denied cert. So they refused to hear the case. So his appeal on the 14th Amendment, this particular one, we don't know what's going to happen. Michigan, Minnesota, and Colorado all have case briefs, all have cases that have been filed now. But this was the first one filed in Florida, the first one that was rejected by district courts, and now his appeal up to the U.S. Supreme Court has been denied. What does the Eastman decision mean in lay terms? It means that the lower court's decision to have the emails that were given to the January 6th committee, that's upheld. They didn't do anything wrong, and that means Eastman can't sue and recover damages for the harm that was done after the committee reviewed the emails. The lower court had said he could, he had some rights to privacy, but that the committee was entitled to those emails. So basically, because the court didn't grant cert for Eastman, it means the lower court's decision stands. This is Florida, right? So keep in mind, Castro has filed cases all over the United States. He's filed multiple cases. And I did not go through his case because I felt it was, out of all of them, really the least polished, the least, convincing of all of the cases. I would say Colorado probably has the strongest case at this point. As far as standing goes, Castro may have the strongest case, but as far as legal arguments go, his case was pretty weak. So the fact that they denied cert is not surprising. It's not surprising, but it gives, again, a little insight into where the U.S. Supreme Court may come down on these issues. Will you show us which one is? Yes, let me, on the bingo card. Yeah, let me grab the picture. That's funny. Oh, all right, hold on. Okay, I'm gonna put it up, so don't be scared. Oh, here we go. So this is Eastman right here. This is Eastman. He was the one, he's, kind of fighting for his life a little bit with his bar, with his bar license out in California. And so a lot of that came about because of the January 6th committee and requesting information. He refused to testify. He refused to be a part of it. So, and then these emails came out regarding his actions and his involvement in all of the cases. And he was upset that the emails had come out. So he had said that was wrong. It was an invasion of privacy. And so he appealed to the U.S. Supreme Court. The U.S. Supreme Court said, no, it's fine. So that's how that went down. That's how that went. Yes, I know. Oh my goodness gracious. Yes. And which is Castro? Castro's not on here. He's separate. He's just an attorney with a couple of law degrees. I'm not sure why he has 2 law degrees, but apparently he's got 2 law degrees. And he has filed multiple cases around the United States, like even in Utah, I believe, and Oregon. But he's filed multiple cases with the same premise regarding the 14th Amendment. So the U.S. Supreme Court here has just said, we're not going to listen to it. So I think that that's really interesting. I think that's interesting. I only have 1 law degree. I'm not sure how many law degrees you need. I guess it's my opinion of that. All right. We're going away now. Putting the bingo card away. So those are the big, those are the big updates from, sorry about that. Those are the big updates then from the U.S. Supreme Court today. We did have 1 oral argument, and we'll see how that turns out as time goes on. But that's the update from the U.S. Supreme Court. Kind of those are some pretty big deals, I think, when it comes down to what's going on in the world of Trump litigation, of which there's a lot going on. So we had all of that. Paper with the elephant's face is better. Oh, it's fun. Yes. It's a good time. It's a good time. Yeah, I think so, A. David. I think that those are some pretty big updates out of the U.S. Supreme Court. The fact that Thomas recused himself, I think, is a pretty big deal. I think that's a pretty big moment. So, yes, lots of trolls. That's all right. We'll just ignore them and they will go away in time. So, I wanted to go ahead and take us through then what we've got for this New York case. Now, again, cameras are not being allowed in the courtroom. I think we knew this would happen, and so no one's really surprised, but we did get some footage of what was going on earlier. He seemed, pretty upset about that. It rained in a bit. Yes. Oh, thank you, VC. I'm so glad. Sometimes I try to add to the blocked words, but sometimes I miss them. So, yes, nope, not 80% of it was thrown out. So, hydrate. Yes, I will. I actually have tea tonight, so I'll take a little drink of my tea and then we'll just dive in. Okay, so now that we've discussed the, thanks, VC. Now that we've discussed the reason why there was no jury, because the attorney didn't request it, let's get into the complaint out of New York. So this is really, I think, important because we haven't really talked about the rest of the counts. We knew they have to do with insurance fraud and regular fraud, but we don't really have the details. So I wanted to take you through the complaint to talk about the details. I will go back again through this order and kind of I pulled out some highlighted points. So we won't go through word by word, but we'll go through it. And in order to kind of see what's important. So this complaint, again, was filed September 21st of 2022. Why no cameras? I think the judge felt that it would just be too disruptive. And, it's the judge's call. That's his court, and he can really, set it up how he wants. So, and I don't think he's necessarily wrong. So, anyway, here's the complaint. And she's put her summons out. But the reason I wanted to show you this complaint was, again, to explain what the counts were. The order that came out last week is just with regards to count 1. So count 1's been decided, and I'll go through that again. But the counts that that are going to trial right now are still in play from this complaint. So I wanted to show you, again, this is her complaint that she set out, and take you through those counts. So she's broken apart all of the misleading statements into all of the different pieces. Can Trump's counsel backtrack and request a jury? No, that's one of those things where if you miss your deadline, and they missed it by a lot too. I mean, it's months later. Their deadline would have been August 15th. So, I mean, maybe 6 weeks, 2 months. Well, you know what I'm saying. I'm not good at math. But the point is, it had to be in by August 15th and they missed that deadline. So that's not something that's really appealable. Yeah, that's not, unless there was if they had asked for a jury and been denied, that decision could be appealed. But the fact that they missed the deadline, no, that's not appealable. So we've got this introduction piece, and so let's get into the causes of action. So let me write out my sticky note here so everyone knows what I'm talking about. So I'm going to go to, this is the New York civil case, and we'll go through the counts here. So counts 2 through 7. All right, here we go. Got my sticky note going. We'll get it up and running here. So, all right, let me just remind everybody what our first count is, our first cause of action. So I keep calling them counts because I'm just so used to criminal court, but they're actually called causes of actions in civil court. So I need to make sure that I use the proper language here. So here's the first cause of action, and I'll take you through that. This has already been decided on a motion for summary judgment. So this has already been determined, but I'll take you through. Very first one, first cause of action, Executive Law Section 6312, persistent and repeated fraud against all defendants. Plaintiff repeats and realleges, plaintiff is the Attorney General, realleges the paragraphs above as if fully stated herein. New York Executive Law 6312 empowers the Attorney General to seek restitution, damages, and injunctive relief when any person or business entity has engaged in repeated fraud or illegal activities, or otherwise demonstrates persistent fraud or illegality in the carrying on or conducting or transaction of business. At all relevant times, defendants have engaged in carrying on, conducting, or the transaction of business in New York within the meaning of Executive Law 63, subsection 12. So we're setting out, again, this first cause of action. So I'm going to take you through all of them, but we'll start with number 1 here. So fraud under Executive Law Section 6312 is broadly defined to include any device, scheme, or artifice to defraud, and any deception, misrepresentation, concealment, suppression, false pretense, false promise, or unconscionable contractual provisions. Number 752. Each paragraph is numbered, so I've just kind of fast forwarded through everything to the counts at the end, or to the causes of actions. Fraudulent conduct. Hold on, I need to switch pens. Sorry, everybody. Hold on. Here we go. Fraudulent conduct, as used in 6312, includes acts that have the capacity or tendency to deceive or create an atmosphere conducive to fraud. And she's citing case law here. The terms fraud and fraudulent are given a wide meaning so as to embrace all deceitful practices contrary to the plain rules of common honesty, including all acts, even though not originating in any actual evil design, to perpetuate fraud. Why is civil fraud? Why not criminal? It could be criminal. It's just she charged it under this particular section, which is her authority as the Attorney General in her state. So she used this section, which has to have the Attorney General involved. So it doesn't have to have any actual evil design to perpetrate fraud or injury upon others, which do tend to deceive or mislead. So persistent fraud or illegality under Executive Law 6312 is broadly defined to include continuance or carrying on of any fraudulent or illegal act or conduct. So it really has to go for continuing actions is really what is the key to this particular section of the code. Repeated fraud or illegality under Executive Law 6312 includes repetition of any separate and distinct fraudulent or illegal act or conduct which affects more than one person. Defendants' acts and practices alleged herein constitute conduct prescribed by Executive Law 6312, in that the defendants engaged in persistent and repeated fraudulent acts. As set forth in the allegations above, defendants made or caused to be made misrepresentations, false or misleading statements, and statements that were misleading by omission, concealment, or suppression of information. All of this conduct, moreover, occurred in an atmosphere conducive to fraud, in which the goal of increasing Mr. Trump's reported net worth on the statements was well known and carried out by his agents and subordinates. Further, all of that conduct was directed towards presenting misleading statements to others, including lenders, insurance companies, and government entities. The acts of fraud alleged here were repeated, entailing, among other things, dozens of specific numerical entries in financial spreadsheets, dozens of verbal representations in financial statements, and other fraudulent and misleading conduct by defendants. Okay, so the acts of fraud alleged here also were repeated in the sense that they affected more than one person under Executive Law 6312. In particular, the acts of fraud alleged herein affected lenders, employees who worked for those lenders, and insurers, the accounting firm, and that compiled the statements and the personnel of that firm. So let me pause for a minute. Now, one of the biggest things that continues to be said, one of the biggest points, I guess, is that he keeps saying nobody got hurt. He keeps saying, nobody sent anything about defaults out. The banks all got paid. Everything got done in time, so there were no victims. But that's what every defendant in white-collar crime says. No one really got hurt. So why should I be held accountable? And, my answer is that's just how the law works. This is kind of like what we would call a strict liability offense. And that means your intent doesn't really matter. It's, did you do this or did you not do it? Who was the victim also doesn't matter. The point is there's a law written and you broke the law. So this huge, kind of idea that nobody got hurt is actually, first of all, it's not true at all, because she just listed out who she felt was hurt in this situation. But also, the law is the law, and the law doesn't always require a specific victim. Taxpayers who had to pay for everything he didn't pay for. Exactly. Somebody always has to foot the bill. There's never any discount where someone isn't making up for that discount. So in this particular situation, that's the kind of, white-collar crime. That's what it's about. It's about following the rules. So just kind of clearing this up. And as she had set out here, who was harmed because of the actions. So we're still on count one, or the first claim. Yeah, true enough, David. The acts of fraud alleged herein were also persistent, which connotes the continuance or carrying on of fraudulent conduct. Here, the key individual players remained the same over the course of several years. Jeffrey McConney prepared or supervised preparation of supporting spreadsheets. Alan Weisselberg reviewed and approved spreadsheets and, as trustee, certified statements as accuracy. Donald J. Trump reviewed and approved statements and certified their accuracy. Donald Trump Jr., as trustee, certified the statements as accuracy. Moreover, these defendants engaged in the same or similar conduct consistently over the course of several years, relying on prior years' information to prepare new valuations, continuing the use of deceptive wording to describe valuations performed, and continuing deceptive strategies used on the prior year's statements. So this is pretty significant. Executive Law 6312 also prescribes as one type of fraud any scheme or artifice to defraud. Defendant's conduct constituted one or more schemes to defraud under Section 6312. In particular, defendant's conduct was committed to obtain property, including bank funds and insurance proceeds, by means of false or fraudulent pretenses or representations. Okay. And flip the page. Again, we're still on count 1 here. So we're going to get into the second cause of action in just a minute, but I did want to review this first piece. That's what the order was about. So, involved and common and closely related techniques, misrepresentations, omissions, concealments of material facts over a period of years, and involved a common nucleus of actors, namely the Trump Organization, its constituent entities, its executives, and its other agents. Citing case law here, holding that it was appropriate to infer the existence of unitary scheme to defraud under penal law using similar factors. Defendants are also liable for persistent and repeated fraud under Executive Law 6312 as participants in a long-running conspiracy. Although not an independent cause of action in New York, a civil conspiracy, if it exists, may connect the actions of separate defendants with an otherwise actionable tort. Citing case law again. Here, the actions of the defendants, including making numerous false and misleading entries and omissions in financial statements and supporting materials in a similar manner over the course of more than a decade, and then submitting them to financial institutions as certified by Mr. Trump or his trustees, reflect the existence of an agreement to commit fraud within the meaning of Section 6312. Citing case law here. Indeed, when asked if he, Mr. Weisselberg, and Mr. McConney, since at least as far back as 2005, had an ongoing agreement to generate false or misleading financial statements, Mr. Trump invoked his Fifth Amendment privilege. Each defendant knowingly participated in the conspiracy and engaged in overt acts in furtherance of it, helping craft the statements, using them to secure favorable financial terms, or certifying their accuracy to third parties. Overt acts in furtherance of the conspiracy occurred as late as 2019, 2020, 2021, and 2022. All right, so let's get into the second cause of action then. So now we're into the next claims. These are what are in front of the judge now, these next actions. So we can kind of figure out what's needed here. Pursuant to Executive Law 6312, repeated and persistent illegality, falsifying business records under the New York penal law against all defendants. Plaintiff repeats and realleges the paragraphs above as if fully and stated herein. New York Executive Law 6312 empowers the Attorney General to seek restitution, damages, and injunctive relief when any person or business entity has engaged in repeated fraudulent or illegal acts, or otherwise demonstrates persistent fraud or illegality in the carrying on, conducting, or transaction of business. So again, this is specific to the Attorney General. Only the Attorney General of the state of New York can bring these cases. But does he have different attorneys for these different cases? He does. This set of attorneys in New York is different from his other sets of attorneys around the country. So this, actually, during his press conference, he said that the banks had very good attorneys, and he made the comment that they were much better attorneys than his own attorneys, which I thought was kind of a harsh dig. But yes, this batch of attorneys in New York is different from his other cases. Oh my goodness. At all relevant times, defendants have engaged in carrying on, conducting, or the transaction of business in New York within the meaning of Executive Law 63-12. Persistent fraud or illegality under Executive Law 63-12 is broadly defined to include continuance or carrying on of any fraudulent or illegal act or conduct. What's the statute of limitations? Yeah, I'll get into that. Statute of limitations has to do with the tolling of the statute agreement that was made. So it's being kind of misstated in the media at this point, but I will get into that once I get into the next order. Repeated fraud or illegality under Executive Law 63-12 includes repetition of any separate and distinct fraudulent or illegal act or conduct which affects more than one person. Falsifying business records in the second degree. New York Penal Law 175.05 is committed with the intent to defraud a person. 1. Or A, makes or causes a false entry in the business records of an enterprise, or alters, erases, obliterates, deletes, removes, or destroys a true entry in the business records of an enterprise, or omits to make a true entry in the business records of an enterprise in violation of a duty to do so, which he knows to be imposed upon him by law or by the nature of his position, or D, prevents the making of a true entry or causes the omissions thereof in the business records of any enterprise. So those are the different elements that are needed that she needs to prove as she's going forward on her case in New York. The elements of falsifying business records in the first degree are met when a person commits falsifying business records in the second degree, and when the intent to defraud includes an intent to commit another crime or an aid or conceal the commission thereof. So we're now talking about the the first degree. The previous paragraph was the second degree. The first degree includes everything in the second degree plus an additional crime. Okay, so that's how they are defining the different degrees of fraud here. Defendants, through their conduct described above, have made or caused to be made false entries and or made or caused to be made the omission of true entries in the business records of an enterprise. Examples of falsified business records or portions thereof identified in the allegations above include false figures used to value properties, false claims that liquid assets belonged to Mr. Trump when they did not, false verbiage on how underlying valuations were prepared, and financial statements and supporting documents that omit true facts. In addition, through their conduct described above, defendants have made or caused to be made false entries and or made or caused to be made the omission of true entries in the business records of an enterprise with the intent to commit another crime or aid or conceal the omissions thereof, including the issuance of a false financial statement under Penal Law 175.45 and insurance fraud violations below. So we've got false financial statements and insurance fraud. All right, so that's what we're in court for in New York. Defendant's conduct in this regard was repeated in the sense that it occurred multiple times and affected more than one person. Defendant's conduct in this regard was persistent because it continued and was carried on over the course of several years. With respect to defendants that are not natural persons, they are liable for additional reasons that the unlawful falsification of records was committed by one or more of their high managerial agents, acting within the scope of the agent's employment. Okay, so consequently, defendants have engaged in repeated and persistent illegality in violations of Executive Law Section 63-12 by falsifying business records. So this was count 2 that she's going to need to go forward and prove in court. So let's go into the third cause of action. Again, when I'm saying counts, I mean cause of action. I apologize. Sometimes my criminal and civil get a little bit mixed. Pursuant to Executive Law 63-12, repeated and persistent illegality conspiracy to falsify business records under New York Penal Law. This is against all defendants. Plaintiff repeats and realleges the paragraphs above as if fully stated herein. The New York Executive Law, Section 6312, empowers the Attorney General to seek restitution, damages, and injunctive relief when a person or business entity has engaged in repeated fraudulent or illegal acts or otherwise demonstrates persistent fraud or illegality in the carrying on, conducting, or transaction of business. At all relevant times, defendants have engaged in carrying on, conducting, or the transaction of business in New York within the meaning of Executive Law 6312. Hey, no problem. Welcome. Persistent fraud or illegality under Executive Law 6312 is broadly defined to include a continuance of or carrying on of any fraudulent or illegal act or conduct. Repeated fraud or illegality under Executive Law 6312 includes repetition of any separate and distinct fraudulent or illegal act or conduct which affects more than one person. No, Lisa. I'll get into that here in a little bit. No, that's incorrect. 80% is not dismissed. Nope. In New York, a criminal conspiracy consists of an agreement to cause a specific crime to be committed together with the actual commission of an overt act by one of the conspirators in furtherance of the conspiracy. Defendants' acts and practices such as making or causing to be made false entries in the business records of an enterprise reflect the existence of an agreement to falsify, flipping the page, statements of the financial condition, supporting data sheets, spreadsheets, and other business records with requisite intent for that conduct to violate the penal law. At least one of the defendant's co-conspirators engaged in an overt act in furtherance of the conspiracy. Those acts included entering or causing to be entered false entries into the business records of an enterprise, or knowingly omitting to make true entries in those business records, or using the statements of financial condition for purposes of obtaining financial benefits. Yes, please be kind to my moderators. My moderators are amazing. I would really appreciate it. Thank you. Thus, defendants engaged in a conspiracy to falsify business records are defined by New York penal law. Defendants' conduct in this regard was repeated in the sense that it occurred multiple times or affected more than one person. Defendants' conduct in this regard was persistent because it continued and was carried on over the course of several years. Overt acts in furtherance of the conspiracy occurred as late as 2019, 2020, 2021, and 2022. With respect to defendants that are not natural persons, they're liable for additional reasons that the unlawful conspiracy to falsify business records was committed by one or more of their high managerial agents acting within the scope of the agent's employment. Consequently, defendants have engaged in repeated, persistent, fraudulent illegality in violation of Executive Law 6312 by conspiring to falsify business records. So we have the actual falsifying, and then we have the conspiracy to falsify. Yes, and the judge cites his deposition multiple times. All right, here is the fourth cause of action. So we're almost done. Again, going into which causes of actions are actually in front of the court at this moment. So that's what we're doing here. Pursuant to Executive Law 6312, persistent illegality, issuing false financial statements under New York Penal Code 175.45. Plaintiff repeats and realleges the paragraphs above as if fully stated herein. New York Executive Law 6312 empowers the Attorney General to seek restitution, damages, and injunctive relief when any person or business entity has engaged in repeated fraudulent or illegal acts or otherwise demonstrates persistent fraud or illegality in the carrying on, conducting, or transaction of business. So I'm going to start skipping through this because these are just repeats over and over and over again. So here it says all relevant times. Persistent fraud is illegal. Repeated fraud is illegal. What is repeated law? So defendants' acts and practices constitute issuing false financial statements under the New York Penal Code. How does 4 differ from 1? Specific financial statements versus business records. Yes, exactly. And also with the conspiracy. So we've got false financial statements versus false business records. And then let's take a look here. So our second cause of action, falsifying business records, right? And then our third cause of action is conspiracy to falsify business records. Our fourth cause of action is issuing false financial statements. And once we get through this, she's explaining what issuing financial statements is, what law needs to be done here, and then we have conspiracy to falsify financial documents. So let me go through what's required for the financial statements, and then we'll skip through to the conspiracy, and then we'll have the last cause. So a person issues a false financial statement under New York penal law when the person with the intent to defraud knowingly makes or utters a written instrument which purports to describe the financial condition of some person and which is inaccurate in some material respect. So again, it's about the documents. So before we had business records, now we've got actual financial documents. Number 2, represents in writing a written instrument purporting to describe a person's financial condition as of a particular date is accurate with respect to such person's current financial condition, knowing it is materially inaccurate in that respect. So, and she's going through and saying that they did that. It was repeatedly, it was persistent. That takes us to the 5th cause of action, which is the conspiracy. So again, you have the charge itself of the actual, or the cause itself of the actual harm, and then we have the conspiracy to commit the harm. So those are both 2 separate counts. So she will go through here and say the same thing regarding the false financial statements, only that here they conspired to do this and that overt acts were done. So this is the addition that's made to this count because it's a conspiracy. So overt acts in furtherance of the conspiracy occurred as late as 2019, 2020, 2021, and 2022. I'm not sure. I think the RICO situation in New York is different than Georgia, but I think this Attorney General just picked which statute she preferred to use, and 6312 is what she was after. So it's brought by the Attorney General. You don't have as many complicated factors here. It really is strict liability. It's very simple. Was the document falsified? If it was, then you're guilty. Much easier than having to go through and have all of these overt acts and proving 2 or more of them and a group of people as well. So I would say a strict liability case like this, much easier to prove, much quicker as well. And it is civil, exactly. I'm not saying it couldn't be charged as criminal. It could, but at this point, it's not really needed. The intent element of it is not as important in the civil case, although that is what the defense can argue, is that they didn't have the intent involved. But it's such a lower threshold in the civil case. That's one of the reasons why, though, they're in front of the judge, is because they're trying to figure out, what was the intent here? Did we have true intent? Meanwhile, with the first count, intent was not an essential element. It wasn't a piece of it, and that's why a motion for summary judgment was fine. But these do have some element of intent, although nothing like you would see in a criminal case. All right, so we had conspiracy, and now the 6th cause of action is insurance fraud under New York penal law here. So we've got 2 counts for falsifying business records, falsifying financial statements, and then we have 2 counts of conspiracy for business records and conspiracy for financial records. Now we're getting into the insurance cause bit. So the 6th cause. And we'll go, again, I'm going to skip through here until I can get just to this particular information regarding this specific count. Let's see. Oh, here it is. We've got the law defined for insurance fraud. This is what she needs to prove on a preponderance of the evidence. A fraudulent insurance act is committed by any person who knowingly and with intent to defraud presents, causes to be presented, or prepares with knowledge or belief that it will be presented to or by an insurer or any agent thereof. In 1, any written statement as part of or in support of an application for the issuance, that's a weird word, issuance of a commercial insurance policy or claim for payment or other benefit pursuant to an insurance policy for commercial or personal insurance that he or she knows to be A, contain materially false information concerning a material fact, or B, conceal the purpose of misleading information concealing any material fact. there too. So let me pause for a minute and just say, whenever you're filling out those insurance forms and there's that signature at the end and you have that little teeny tiny print that says, I swear everything I wrote above is true to the best of my knowledge, and then you sign that, like if it's not actually true, that's what this is. This is a violation of that, stating, yes, it's all true. Everything I put in this document was true. So this is where you can get charged if that information isn't actually true. So they're saying here, this is the intent level, by the way. Knowingly, with the intent to defraud, caused to present or prepared written statements in support of applications that they knew were false. So the insurance is the next piece on here. Yes, the expectations of honesty, and also the fact that you're signing it. You're basically creating a contract saying this information is true and correct. And if it's not, you can be charged. And then next, the last cause of action is the conspiracy then to commit the insurance fraud under New York law. So again, all of this language is the same. We're citing, again, what a conspiracy is here, repeated pieces of fraud. And then specifically to this, the defendants engaged in a conspiracy to commit insurance fraud as defined by New York penal law. Need your sticky... Oh, sorry. I forgot. I lost track of my sticky note. Thank you. Sorry about that. All right, here we go. So, defendants was regarded as repeated over and over and over again, and it was persistent. So, yes, the banks can sue for damages now too. Yes, exactly. Yep, they certainly can. So that takes us then through all of the counts. Sorry, the sticky note's going. That takes us through all of the accounts, but then let's go through and see what she's asking for. So this is her prayer for relief. Again, this is just a legal term. We always say what we're requesting at the end. We call it a prayer. That's just part of our legal vernacular. But this is what she's trying to get at court. So let's take a look and see here. Pausing for hydration break. One moment, please. Okay, here we go. So, this is what she's asking for. Plaintiff respectfully requests the court enter an order in judgment granting the following relief. So, A, canceling any certificate filed under and by virtue of the provisions in this section 150 of the General Business Law for the corporate entities named as defendants and any other entity controlled by or beneficially owned by Donald J. Trump who participated in or benefited from the foregoing fraudulent scheme. So that's A. B, appointing an independent monitor to oversee compliance, financial reporting, valuations, and disclosures to lenders, insurers, and authorities at the Trump Organization for a period of no less than 5 years. C, replacing the current trustee of the Donald J. Trump Revocable Trust with new independent trustees and requiring similar independent governance in a newly formed trust should the revocable trust be revoked and replaced with another trust structure. D, requiring the Trump Organization to prepare on an annual basis for the next 5 years a GAAP compliant audited statement of financial condition showing Mr. Trump's net worth to be distributed to all recipients of his prior statements of financial condition. Whoa! So he would have to send this to everyone that he had ever sent statements to. Ooh, that's a lot. Barring Mr. Trump and the Trump Organization from entering into any New York State commercial real estate acquisitions for a period of 5 years. All right, so 5 years. Barring Mr. Trump and the Trump Organization from applying for loans from any financial institution chartered by or registered with the New York Department of Financial Services for a period of 5 years. Permanently barring Mr. Trump, Donald Trump Jr., Ivanka Trump, and Eric Trump from serving as an officer or director in any New York corporation or similar business entity registered and or licensed in New York State. Again, this is the original complaint. I'm not sure if this would apply to Ivanka now. She was removed from the case, so I'm not sure. And then I permanently barring Alan Wesselberg and Jeffrey McConney from serving in their financial control function of any New York corporation or similar business entity registered and or licensed in New York State. Ooh, that's pretty significant. Yikes, that's a pretty big ban. Oh my goodness. Awarding disgorgement of all financial benefits obtained by each defendant from the fraudulent scheme, including all financial benefits from lenders and insurers through repeated and persistent fraudulent practices of an amount to be determined at trial but estimated to be $250 million, plus prejudicial interest, and K, granting any additional relief the court deems appropriate. So this is the this idea of disgorgement. We kind of talked about that before in his order, where she's saying this is the harm that was done. So this needs to be paid back in order to make the harmed parties whole again. So that's what this disgorgement means. Okay, so that is the original complaint then filed by the Attorney General's office. Could Trump put his wife in charge of his business? I'm not exactly sure how that would work. She's not named, but the other thing, though, is that they have to have an independent person coming in. Like they have this retired judge that's overseeing everything. So I'm not sure how much of a difference it'll make to just move it to somebody else's hands at this point, especially when you have to dissolve the certificates. But maybe I would say it's not out of the realm of possible. Yeah, $250 million is a lot of hurt. That's very, very well said. It is. And if you think about all of the different banks and different companies, it really is quite a bit of damage. He's not allowed to do business. Whoops, I missed your comment. And he'd benefit from the business. Right. So, yeah, if his wife was to take it over, he would essentially be doing that, but what are the counts after 2014? Okay, right. So let's talk about this, okay? Let's get into this issue. At this press conference that he said after the testimony today, okay? So he came out and he said that the judge had ruled on this statute of limitations issue, and so 80% of the case was gone, right? That's incorrect. All right, that's incorrect. I'm going to take you through this order and I'm going to explain to you what the statute of limitations argument is. Now, the judge has already ruled on the statute of limitations issue. So what Trump was bringing up, I believe, was this question of 2011, 2012, 2013. So 3 out of all of the years, the judge is considering not allowing that evidence to come in for those 3 years. But you have to keep in mind, they have all the other years from 2014 until 2022. They have all those years of records too, right? So we've got this big batch of years. We've got 2011 to 2020, 2022. So we have 11 years. And they're saying, well, we may bump 3 of those years out. So they still have all the rest of the years of evidence. So it's not going to have any kind of an effect on the actual case itself. But at this point, of course, I think if Trump sees this as a benefit to him, then he should celebrate that, because there are not very many benefits in this case. So if he thinks that that was a good order or that was a good holding, so be it. But will it have an effect on the case? No, it won't. Instead of 11 years, we're subtracting a couple of years off of there. There's still so much evidence. And as I take you through the highlights in this order again, you'll see the majority of these cases are 2014 and after. So even this question of 2011, 12, and 13 isn't going to affect anything. So I'm not sure, again, exactly what the ruling is, because we don't have an order yet. But that's what this whole question's been about. He came out and said 80% of the case is gone. That's just not true. I would say 80% of the case is still left. So maybe he flipped his numbers around and meant to say 20% is gone. I don't know. But, there's plenty left in this case to go forward. Might affect the total. Yeah, it might take 250 million down to, 245 million. I don't know. But why was Ivanka removed from the case? She did not sign the tolling agreement. Now, here's the deal with the tolling agreement. There was an agreement signed. Hold on, let me just grab it. Okay, so we had an agreement that was signed. All right, this is the actual agreement. This is Exhibit A. Exhibit A. Okay, so we had this agreement between Trump and his companies and the Attorney General's office. This agreement was signed on where's the signature line? I don't know when the signature line is. Sorry about that. But, late 2022. I think it was November of 2022, perhaps. I'm not sure exactly. Hold on. I can't go forward if I don't have that information. Just a minute. Let me get the accurate information here. I'll look in the order here. Sorry about that. I've just got to get confirmation before I start talking about it. Discovery. One moment. Okay. All right, so again, sorry, I'm trying to find that exact date on here of when it was signed. The tolling agreement at issue here. All right, so the agreement was extended one time by an amendment dated May 3rd. So the original agreement was on August 27th of 2021, and it was amended May 3rd of 2022. Okay, so there was this, now that I've got those dates, I can go forward. All right, so this agreement was made between the Trump Organization and the Attorney General's office. And in it, they said, we want to pause the tolling period of the statute of limitations. So every single case has a statute of limitations. If you don't bring your case within that period of time, then you lose it. And so the AG said, hey, we're about ready to sue you guys for all this stuff. And they said, whoa, we got stuff going on. Can you not sue us? And they said, well, all right, but, we're going to pause the statute of limitations. And they said, okay, we agree to it. So everybody involved in this agreement, all of the charges or all of the claims can be brought, and the statute has not run. There was one person not involved in the Trump Organization at the time this was signed, and that was Ivanka. Because of that, she is not then covered by the tolling agreement, and the statute of limitations ran for her. Hydrate. Yes, thank you. So that's why she's not included. She was dismissed from the case because she was not involved in this agreement, and so she is out as one of the parties. It wasn't because she didn't do anything wrong. It was because she was not included in this agreement that told the statute of limitations. Okay? It's tea time. Yes. All right, so here's the tolling agreement that we were talking about before. Now, in here again, it just states they have the right to extend the end of the tolling period from October 31st to April, and then they extended that even further into May. So this agreement basically benefited Trump because then the AG did not bring the suit sooner, right? He keeps saying one of the things that his attorney argued in opening statements today was, well, why didn't they bring the suit, years ago? It's because of this agreement. They agreed to not bring the suit, and they paused the statute of limitations. A sentencing or just the beginning? Oh, it's just the beginning. Today was just opening statements and they had one witness up. So that was it. Yep. Oh, you're welcome. Absolutely. Sure. So is everyone following me then on the statute of limitations question? Okay. So Ivanka's not involved. And because of this statute of limitations questions, I will get into what the judge was talking about, and we'll talk about this 2011 versus 2014. So today the witness was Donald Bender. So let me write his name down. Donald Bender. I'm not sure that he finished testifying. He may be back to testify more tomorrow, but this was the state's witness. He was brought in to testify regarding, the financial practices done in the business. So he was the only one who was testifying today. They did opening statements and then called him to testify and then closed the day with that. So that he was the only one that testified today. There'll be many more. Michael Cohen is going to be testifying. I have no doubt. There will be many others called in to testify. Trump could be called in to testify. Ivanka could be called in to testify. Unlike in a criminal case where defendants aren't compelled to testify, in a civil case, the state can call any of these people in to testify. They can all be witnesses. Now, if they choose to actually, plead the fifth or whatever, that's up to them. But the state can actually call them in to testify in this situation. They showed Cohen's testimony. They showed his testimony during the during his testimony in front of Congress, which was what triggered all of this investigation. He was called in, I believe, in 2019, and he testified about the financial situation behind the curtain, and that's what started this entire lawsuit. So that's how this all got started, was from his testimony. So he'll be brought back in again to testify. All the kids, yeah, and I don't doubt it. Right, criminals guilty beyond a reasonable doubt, but in civil court, it's upon a preponderance of the evidence, which means 51% at fault is the key to a civil case. Yep. Right, a preponderance of the evidence. So 51% is typically how we... Jeez. Yes. Can Mazars' accounting firm be charged? It's possible. It's definitely possible. Why did New York bring the lawsuit and not the banks? It's priorities. The banks can bring their case whenever they want. The New York AG, the Attorney General, it's within her authority to bring the case whenever she wants as well. So she did an investigation and brought the case when she felt it to be an appropriate time. The banks may or may not sue. It's up to them if they want to go through costly litigation or not. If it's worth it, they'll make that determination. But for her, it's in her job description. Like, she's required, because of her duty as the Attorney General for the state of New York, she's required to bring these kinds of cases. So that's why she brought her cases. Yeah, I think, the pen details. I think I think it just had to be, if you look at all the filings in this case, this is a BIC, but if you look at all the filings in this case, and it's all my colors, the timing is perfect. I mean, the timing on it is just when it should be. She's been fighting this for years. She's been sued. There have been all kinds of cases going on. And so when things were filed on this case, it was absolutely an appropriate time. So the timeline looks absolutely correct and just needed to, keep going forward. Why can't we see all of their taxes? Yeah, I don't know. I'm not sure exactly what the privacy rules are on that, so I'm not sure. There was a clause in the contract stating that his numbers may be wrong. Yes, so right. So let's start picking this apart. Let me get a sticky note out here so I can tell you what we'll go through, and I'll take you through the statute of limitations, and I'll take you through the what do they call it? The bad clause. Hold on, let me label my sticky note here. Okay, New York. Civil case order. All right, so let me start walking you through this. I learned so much. Oh, I'm so glad. Oh, the worthless clause. Thank you, Daisy. You got it. You got it. The worthless clause. Yeah, the judge was not impressed with that. All right, so let's start walking through. Let's go back through this. The bad man clause. How can New York get involved in Florida property? It depends on, what information. If information is being put on documents in order to get loans in New York, if he's trying to say, look at these other properties I have, I've got all these assets, and they take those into consideration, then that's how Florida gets involved. He basically brought them in as, assets. Get some clear sticky notes. Yeah, sorry. I just kind of grab what I have here. That's funny. Oh, that's so funny. All right, so here's the order. Let's take a look again. Let me break it down for you here. What we've got. This is the order that came out last week, and I've spent some more time kind of going through this to see if we can get things sorted out. We've got a partial summary judgment. So Ms. James already requested on the first cause of action, right? She asked for her motion for a summary judgment on there, and that was granted. The summary judgment regarding these documents for the first count is what was issued here, and then sanctions for the attorneys. So that's what's been set out here. He starts us out with the procedural background. Now, something interesting about New York is the district court, the low-level trial court, is actually called the Supreme Court. And so that's why there's multiple levels. The second court up is the appeals court. And then after that, they get into different designations. So that's a little bit confusing if you're going through the case. You're like, which court is it? So we've got the Supreme Court of New York right here, which is their trial court. So that's where the procedural background is starting. Now, during that proceeding, the AG's office and the Trump Organization, so during this previous proceeding in court, they had entered into an agreement which, broadly speaking, told the statute of limitations from November of 2020 through May of 2022. Can he lose Mar-a-Lago? Anything's possible. He's got to settle debts from the dissolution. If part of that is paying off creditors and he doesn't have enough assets, it's possible. So this is why we have the whole statute of limitations, this whole tolling of the statute, right? This whole issue is all because there was a lawsuit going on. And in this particular case, during that proceeding, the Attorney General and the Trump Organization entered into this agreement. So it paused the statute of limitations. And this is that agreement, okay? So if you're wondering why this happened, it's because of this. Now, the statute of limitations that he's talking about, I really don't know. I really don't know exactly at this point. His attorney said something about 2011, 12, and 13. But what he said in the press conference after today's stuff, it doesn't make any sense, and there's no order to back it up. So I don't have anything that I can back that up with. Can he file bankruptcy? Yes. Yep. Told for 1.5 years, the statute would be 11.5. Right. So again, without that order, though, I don't know specifically what he was referring to in that. But let's just say, for some reason, that they bumped off a couple of years. Again, it will make no difference in the end. So this is that statute of limitations issue. All right. And it's because this case had been brought in 2020 and everything just was paused based off of that. So November 3rd of 2022, so just a few months after this, the court found preliminarily the defendant had a propensity to engage in persistent fraud by submitting false and misleading statements of financial condition. So just a few months after the agreement, the court found there was this propensity for fraud. And so that's when we need to get an extra person, a third party appointed to the case. So, accordingly, the court granted a preliminary injunction against any further fraud and appointed the Honorable Ms. Jones as an independent monitor to oversee the defendant's financial statements and significant asset transfers. Have to admit to the world, yeah, he would in order to go forward on a bankruptcy, but he's done it before, so I don't know. And at this point, with his PACs running, there's plenty of money in there. So, all right. So she was appointed then in November of 2022 as the special kind of third-party overseer of the situation. To take a look at his assets and going forward on that. We had a motion to dismiss that was denied. And then that takes us then to January of this year. And January, an order went in from the appellate division. So the appellate court has already heard this case, modifying the court's order to the extent that declaring the continuing wrong doctrine does not delay or extend the statute of limitations. 2, finding that claims are timely against defendants subject to the tolling agreement if they occurred after. So I guess this would be that year that they're talking about. So let's just revisit what this is saying. We have the appeal order declaring continuing the wrong doctrine or extent does not toll it, finding the claims are timely against the defendant subject to the tolling agreement if they accrued after the 2014. So I think this is what he's talking about. Okay, everybody, when he came out and said after the testimony that 2011, 12, and 13 weren't included, it's because of this line from the appellate decision claiming anything after 2014. Okay, so I think that's where we got that from. And timely against the defendant not subject to the tolling agreement if they occurred after February 6th of 2014, and dismissing the complaint as against defendant Ivanka Trump on statute of limitations ground, finding that she was not an employee of the Trump organization at the time at which the parties entered into the tolling agreement. All right. Yep. 2014 and after. All right. So there are a few times when references are made to 2011, 12, and 13. I mean, there are a few in there. So maybe the judge is saying, let's just focus on everything after 2014, of which there's plenty, of which there is much evidence that is allowed. So, and then Miss Ivanka was out, and this was decided earlier this year. So there's a lot of stuff going on in this case. There's a lot of stuff going on. The appellate division declined to dismiss any other defendants or any other causes. So we're, again, looking at that appellate judge's decision. We had discovery ending July 28th. Now, remember, July 31st, right? July 31st is where the note of issue came in, where she checked, we do not need a jury trial, and he did not respond within his 15 days. All right, so discovery ended on the 28th, and then let's just make a note here. July 31st was the notice. Note of issue, and he did not respond, and that's why he does not have a jury trial. Can they charge Ivanka separately? No, her statute of limitations is already run, so they would have to find a different charge that didn't have a statute that ran already. Yep. All right. So here we've got, right. So it says this is the moment. Again, I'm trying to really make this as obvious as I can. Where the judge is saying, this is the note of issue. So he's even saying she filed the note of issue for the jury trial shortly thereafter. So it's even in his order. This is it. This is the jury trial issue. I just can't emphasize this enough. It's really something that I really wanted to nail down here. Okay. So jury trial was because of their attorneys. His attorney. It's his attorney's choice right here. Blah, 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 right there. Bench trials more difficult to succeed versus jury trials. I don't think so. I think things go a lot quicker with the judge making the decisions. But I think, it's advantageous for him to be in front of a jury because there's the potential for one of them to be empathetic towards him. And, you only need a couple of them to throw off the verdict. And you just don't have that with a judge. The judge is like shooting straight and has been doing this for 20 years. He knows the law. He knows what's going on. He's known this case for years. So, he's just doesn't need any kind of baloney involved. Yeah, it's better for the plaintiff. I would say so in this case. Who's responsible to pay the financial penalty? Well, yeah, that's a good question. I think that would be assigned. It could potentially be assigned by the judge. 10 of the 12 in New York. Oh, okay. That's good to know. Malpractice, maybe. He's already said he wasn't very happy with his attorneys. Adnan, I don't have any thoughts about that at the moment, but, you know, that could change. Oh my gosh. All right. So here we go. Yeah, I mean, judges aren't partisan, dude. That's just against their ethical rules. So, you know, and especially this guy that's been on the bench 20 years. All right, so let's take a look here. We've got the procedural history, and we've got the executive law set out here under 6312, and so that's been explained as well. So then the next piece of the order, the defendant's motion for summary judgment on all causes of action. So here he's going through the same arguments the defendant had brought up before, and he was not impressed, right? So spoiler alert, they've been denied. Oh, hydrate. Yes. Thank you. Oh my goodness. Yes. So I'm just going to hit the highlights. This will be the highlighted version here. So the first argument that the defendant said was there's no standing, no capacity to sue. And the judges, made the reference to Groundhog's Day, the movie, because he says, we've already decided this over and over and over again. The district attorney under the law has the power to sue under this section of the code. So that's just what it is. The next argument he raised was the parens patriae and consumer gambit. So again, he's saying that the Attorney General can't demonstrate the requirements of a parens patriae action. Typically, a parens patriae action is what gives the state authority to come in and help children. So it's the same kind of situation when you're dealing with a business situation, but it permits the state to commence an action to protect a public interest, like the safety, health, or welfare of its citizens. The judge is saying, no, that argument's not working either. So we'll skip through that. Yes, we'll skip through that. Parens patriae, just remember that. That's what's in our juvenile court docket. That's was a case called, let me just write the case out here. There was a case called In Re Galt, which established the ability for the state or the government to step in and act as parents when a child needed it. All right, so this is the case here. So just in case you're wondering, little FYI for you. It's a little FYI. In re Galt, it's a great case. All right, so moving on. Parens patriae is not working, and so he's just saying it's not working here, or here. So, and he's saying your case law is wrong, your legal theory is wrong, so let's move on. The next, this is number three's piece for their motion for summary judgment. Again, they're trying to get the case tossed. The next piece is non-party disclaimers. The court said we've already got a prior order. We've got a legal test. You didn't meet the legal test. So no, that's not going to work. We're still keeping the case. Also bringing in that the Mazars disclaimers put the onus for accuracy squarely on the defendant's shoulders. So even going after the company and saying, they told you what you needed to do and you didn't do it. The next argument they have here for their motion is scienter and participation requirements. Scienter is our civil intent requirement. So they're saying there was no intent involved in this particular case. Now this is going to be important because they're probably going to continue to argue it on the other counts. So let's look and see what the judge holds here. It's well settled that the definition of fraud under subdivision 12 of section 63 of the executive law is extremely broad and proof of scienter is not necessary. So the judge has held this intent level is not necessary under 63 subsection 12. We'll see how that plays out in court. Again, we're citing case law here. So liability, and this is specific to this code section, does not require demonstrating an intent to defraud. And we've got multiple cases that the judge is citing here. This, I think, will definitely be a question at trial regarding that. So next, this is what are we on? Number 5? Number 5, disgorgement of profits. Again, this is that argument where they're saying nobody got hurt. So none of the banks were harmed. None of the insurance companies were harmed. Everybody got paid. So there was no harm. So then there couldn't be any kind of damages to bring a lawsuit, is what they're saying. That's his argument here. And the judge is just saying that's incorrect. He's not really even beating about the bush. He's just like, listen, we're wrong. That's wrong. So in this particular situation, there are victims. There was harm that was done. And just by saying everybody got paid does not alleviate the harm that was done. This is one of my favorite pieces. Defendants correctly assert that the record is devoid of any evidence of default, breach, late payment, or any complaint of harm, and argue that as none of the recipients of the subject SFCs ever lodged a complaint or with the AG or otherwise claimed damages, disgorgement of profits would be inappropriate. Now remember, the AG is asking for disgorgement. That's where that $250 million came from. So they're saying there was no harm, so no amount of damages need to be done. And the judge is just saying that's incorrect. So as he goes through it, he does a pretty good job setting out why it's incorrect. So let's look at this disgorgement question, because again, they're saying there was no harm done. And the judge is saying here that the Attorney General can seek injunctive and other relief, finding the Attorney General can seek disgorgement of profits on the state's behalf. So she can go forward and she can say, what were the actual damages that were done because of your actions. Right. Yes, exactly. Not to the rich people. That's a good point. All right, where were we? Was this number 6 now? Sanctionable conduct for frivolous motion practice. All right, so we've moved on at this point. His summary judgment requests to have the case dismissed, those are going to be denied. So now we're going to move into the part of his opinion where he's talking about sanctions. So sanctionable conduct for frivolous motion practice. So as attorneys, if we do anything in bad faith throughout the lawsuit, it can be pleadings, motions, whatever. If we do anything in bad faith, we can get called out on it. And so he's saying, I'm calling you out on this. He said repeatedly, we had a request for a preliminary injunction, and to the defendant's motions to dismiss, the court rejected every one of the aforementioned arguments. In rejecting such arguments for a second time, this court cautioned that sophisticated counsel should have known better. However, the court declined to impose sanctions, believing it had made its point. Apparently, the point was not received. So this is some pretty harsh language the judge is setting out here regarding the motion practice. Now, again, I would remind you, we still have motion practice like this out of the case in Florida, right? If you remember the Trump versus Clinton case that we talked about, where that judge also set out sanctions as well. Okay, one would not know from reading defendant's papers that this court has already twice ruled against these arguments, called them frivolous, and twice been affirmed by the First Department. So even the Court of Appeals has affirmed the court's decision on this. So we're going into discussion of financial sanctions. Defendant's conduct in reiterating these frivolous arguments is egregious. We are way beyond the point of sophisticated counsel should have known better. We are at the point of intentional and blatant disregard of controlling authority and law of these cases. The court emphatically rejected these arguments, as did the First Department, so the Court of Appeals. Defendants' repetition of them here is indefensible. Yeah, exactly, Suze. He is mad. This judge is mad. So he's pretty upset. And the footnote, by the way, that I skipped is also worth noting. The court even went so far as to caution that the arguments were borderline frivolous even at the first time the defendants made them. So they kept going. They kept going repeatedly, and the judge called them out on that. That's what sanctions are for. So he goes into, the judge says, we've got number one without a doubt. So that's where he was able to find the authority then for the sanctions that he set out. Defendants' inscrutable persistence in re-presenting these arguments clearly satisfies the first of these three possible criteria. So, and then he goes into the standards again for issuing sanctions and the authority that he has. So he goes through that, goes through a couple of different pieces, saying January 6th of 2023, decision in order, the court warned the defendants that the reiteration of these previously rejected arguments scattered across 5 different motions to dismiss was frivolous. So even citing the court document telling them this is frivolous. He also goes into this affidavit, right? So we had an honorable judge who wrote an affidavit or wrote out something to give to the judge to go into why they keep filing these things. And the judge is saying the legal arguments are not relevant. First of all, and he gets really frustrated as well because he says nobody asked here. Neither defendants nor Justice Austin has sought permission to file an amicus brief. So this judge that came in to try to bolster the defense, he didn't even ask if he could file a brief on behalf of the defense to help the court. He didn't even ask, and that's like way out of line. You can't just assume a court's going to accept your brief explaining things. You need to go through proper procedures in order to do that. So he did not. In their own submissions, defendant have expounded on the law, capacity, standing, disclaimers, motions to dismiss, motions for summary judgment, and sanctions. The heft and prestige of a legal lion adds nothing. So again, they pulled this judge in to try to explain what motions to dismiss are, how they should be done properly, how sanctions should be done properly, and this judge is not impressed with that. Not impressed at all. So he said, nope, it's not helping. Oh, I need the sticky. Yep. Thank you for reminding me. I forget, everybody. Sorry. I'm a bit absent-minded sometimes. All right. So here we go. Let me get this in here. Yes, I appreciate you reminding me. I forget. All right. So he's going to go on and explain that he understands what the rules are for standing. Another piece is the capacity. That was one of the things that was argued and said infants legally declared incompetent and persons under certain legal disabilities are not allowed to sue. Claiming here the New York Attorney General is none of those above. So again, these arguments, he's just going through and explaining how defense's arguments are inappropriate. So again, we've got more arguments made by defense counsel here. Yes. And another comment, exacerbating defendants' obstreperous conduct is their continued reliance on bogus arguments in the papers and oral arguments. So he was not impressed by oral arguments. So the judge will just continue to go on. Thank you for the reminder, everybody. We'll continue to go on and say, hey, we had to have sanctions and because of bad conduct, and we will have them again. Again, these arguments were invalid. He told the defense they were invalid and they kept going forward. So they did have prior sanctions. The People versus Trump, again, there was another situation. So there is also a larger context to the sanctions issue. In this case, several defendants are no strangers to sanctions and why courts are sometimes constrained to issue them. In the investigatory special proceeding, this court found Donald Trump in contempt of court and sanctioned him $10,000 per day for failing to comply with his discovery obligations, much like Giuliani, although Giuliani's punishment was a default judgment. The court lifted the contempt after 11 days. The First Department affirmed the contempt and the fines. Does legal disability mean personal incapacity? I would say so. That seems to be what they're talking about here. I think he's making a point again, just that the defendant's pleadings are inappropriate and that their claim that the Attorney General is incapable or doesn't have the capacity to bring the suit is incorrect. I think that's what the point is here. So, yes, we had prior cases where we had sanctions involved, and then he's also even citing the Trump v. Clinton case out of Florida, where Judge Middlebrooks denied the order in this case, and using this phrase, he denied this motion to re-argue, and sanctions were given out in Florida, which came to the amount of about $1 million. In fines for the attorney and Trump. So both of them were part of the sanctions out of Florida. So he's just going on a little bit more to talk about these sanctions. Why wasn't the defense called into contempt today? I'm not sure. We don't really have all of the details of what happened, but I'm not sure that they, if they haven't crossed the line. I don't think this judge is going to take any funny business. So I think when appropriate, he will sanction if it needs to occur. So I really trust this judge to find those situations. I'm not sure that there would have been an appropriate contempt situation yet. But, some people are saying we're looking at 3 months. We're looking at 3 months for this trial. So yes, so we had opening statements today from both sides, and then we had one witness. Will they release a transcript? Maybe at some point, but I'm not sure when that will be. How does he even have money to run for 2024? Yeah, he's got his political action committees for sure. There's plenty of money. They've been putting millions of dollars into his legal fees so far. So, and that's completely acceptable. If you're running for president of the United States and you have a political action committee, you can use the funds in those PACs to pay for your legal bills. That's absolutely allowable under the law. Yep. Yeah, and that's who's paying for it. So all of these donations, again, millions of dollars are going for legal fees, and they're coming from his political fundraisers. Yeah, it's perfectly legal. I'm not saying it's good or bad. It's just legal. So yeah, he's paying a lot. All right. So again, he's just going in further with the explanation of why sanctions are appropriate. So I've highlighted in orange. Anytime you see orange is the actual holding of the court. So this is his claim now for the sanctions. Accordingly, the court grants the AG's motion for sanctions in part to the extent of sanctioning each of the defendant's attorneys who signed their names to the instant legal brief in the amount of $7,500 each to be paid to the lawyer's fund for client protection of the state of New York no later than 30 days from the date of this order. So each of these attorneys then are required within 30 days of this order to pay $7,500 as their sanction. So, and if you saw, did anybody notice when you saw him talking today, or even when he was sitting at the table with his attorneys looked pretty banged up mentally. Honestly, and if you get slapped with this kind of a fine, $7,500, they know that they got dinged pretty good. Yeah, they did. Yeah, I know, right? I know. Can the attorneys get Trump to pay? No, it's there. The judge is pretty clear. These attorneys screwed up. Counsel should be the first line of defense against frivolous litigation. They knew better. They continue to bring it. So he dinged them. He dinged them really hard. This is a pretty significant sanction, especially for all of the attorneys. Professional misconduct. It is. Absolutely. Right. And it's possible, these kinds of sanctions would be seen as plenty, not needing to have a bar complaint against them for it. So I'm not sure that there would be any kind of a bar complaint, but it's a significant sanction for sure. When you look at how infrequently attorneys get sanctioned at this level, this is pretty significant. All right. So that then takes us to the next piece, which is arguments defendants raised for the first time. So all of these previous arguments had all been raised before, and the judge said they're bogus. That's why we've got sanctions going. So the first is the summary judgment standard. So the judge sets out what is needed in order to ask for a summary judgment, citing case law in that. So that's the first piece here. And then going into the defendant's different arguments, and he's saying their arguments misstated the law, and why they misstated the law. So that bumps us to the worthless clause, which we had been talking about before, which was the next big piece I wanted to get into, was this idea of the worthless clause. We've discussed this a little bit before, but let's go into it. So the defendants rely on what they call a worthless clause set forth in the SFCs under this section entitled Basis of Presentation that reads as here pertinent as follows. So let's get into the worthless clause here. Assets are stated at their estimated current values and liabilities at their estimated current amounts using various valuation methods. Such valuation methods include, but are not limited to, the use of appraisals, capitalization of anticipated earnings, recent sales and offers, and estimates of current values as determined by Mr. Trump in conjunction with his associates and, in some instances, outside professionals. Considerable judgment is necessary to interpret market data and develop the related estimates of current value. Accordingly, the estimates presented herein are not necessarily indicative of the amount that could be realized upon the disposition of the assets or payment of the related liabilities. This is the key. This is the key to this whole worthless clause that he's claiming supports everything. This line right here. So the estimates are not necessarily indicative of the amount. And so he's saying the numbers we're giving you might be wrong. You need to go look them up yourself. Yeah, that's what he's saying here. So he's relying on this particular clause that's been added, saying, we just estimated it. And if our numbers are wrong, so be it. But you should go look it up yourself. This is the key. And then the use of different market assumptions and or estimation methodologies may have a material effect on the estimated current value amounts. So he's trying again to use this clause to say whatever numbers I put down are covered by this clause. And if you didn't realize it, that's on you, not on me, because of this clause that's included. All right. So keep that in mind as we go through the judge trying to explain why this is bologna sandwiches. This judge cracks me up. All right, here we go. Let's get into it. Additionally, as discussed, a defendant may not rely on a disclaimer for misrepresentation of facts peculiarly within the defendant's knowledge. And we're citing a case law here. So this is the law. So this disclaimer that he put in there, this worthless clause, the judge is saying you can't rely on a disclaimer like that when you're misrepresenting facts that only you have knowledge about. So he goes on to say here, as the valuations of the subject properties are obviously peculiarly within the defendant's knowledge, their reliance on them is to no avail. Where can I get these to read them? Okay, so if you want this particular order, you're going to just go online and you can put in the people of the state of New York versus Trump civil case. But this also, you can ask for the Engoron opinion order. Any of those search terms will get it and it'll pull this up. If you're looking for the New York docket itself, let me give you that citation name. And if you go into the New York docket, you can pull up all of the exhibits. Everything that's listed, you can pull up. And let me just give you the app where I've got it pulled up here. Not the app, but the website. Let's see here. NewYork.us. All right, so this is the website, and you can find the hundreds of documents that have all been filed. You might have to do a little hunting around to find the exact case, but this is the website that has the New York documents. Okay, so that's all available. Again, you want the people of New York versus Trump. Yep. All right, so here we go. Let's keep moving on this worthless disclaimer. So I think this is good information to know. Like, everybody thinks attorneys try to sneak stuff in all the time, and it's because of this kind of bologna sandwiches that happens. Because, you know, we'll put in something, a particular piece in a contract or something, and you don't read it and you feel like, oh, the attorney kind of messed with me here. This is what the judge is saying. Like, we don't do that. That's not allowable. You can't misrepresent only facts that you can do like this, and then use a disclaimer to get out of liability. There we go. How's that? Is that better? Is that better? Let me make sure. Move to the left. Okay, to the left, to the left. How's that? Okay, I think what happens is I hit my table and my tripod moves. Perfect. Okay, thank you. So yeah, you got to kind of keep me up to date. I appreciate it, everybody. Oh my goodness. All right, all right. So here we go. The defendant's the one that has the knowledge of his financial information. And by putting in a disclaimer saying that his, you know, nothing he says could be true, you can't do that. It's not allowed. So the judge goes on to hold, thus the worthless clause does not say what the defendant says it says, does not rise to the level of an, oh, thank you, so cute, so cute, of an enforceable disclaimer, and cannot be used to insulate fraud as to the facts peculiarly within the defendant's knowledge, even vis-a-vis sophisticated recipients. All right, so he's saying you can use this clause all you want, but it doesn't say what you think it says, and either way, you're still liable for the damage. So next we've got the tolling agreement. Now we talked about that already a little bit, and this was that agreement that was signed between the Attorney General's office and the Trump Organization, right? So we are going to pause the statute of limitations so they can bring their suit later and they get a benefit from that. So we had the first departments declared claims are timely against the defendant subject to the tolling agreement if they accrued after July 13th of 2014. So this is that piece he was talking about earlier regarding the tolling date between 2011 and 2014. And claims against the defendants not subject to the tolling agreement are timely if they accrued after February of 2016. The defendants concede the tolling agreement binds each of the LLC defendants and the Trump Organization. However, they argue that each of the individual defendants and Donald J. Trump Revocable Trust, wanted to say thank you, learning a lot here. Oh, I'm so glad, are not bound by that agreement. Now, the judge is not having any of this and is saying, look, you guys agreed to this. You both benefited from it. So, thus, the tolling agreement at issue here binds all directors and officers and present or former parents of the Trump Organization and its affiliates. So the binding agreement is good law. It's standing. It's a contract created by the two parties. And yeah, so you signed it. And so now you need to uphold your piece of it. Because without this agreement, this case couldn't be brought because the violations had occurred at a time that would not have been covered because the statute of limitations had run. All right. Is everybody following that analysis? That the many of the instances would not have been allowed to be used had the tolling of the statute of limitations not been paused. Yes, they agreed to it. They all agreed to the statute of limitations being paused so that it wouldn't run. And in exchange, then the lawsuit that they were in the middle of had been paused as well. Okay? Yep, it was all agreed upon. The only person that didn't agree to it was Ivanka, and she's out of the suit because of it. So, which, you know, was her prerogative. All right, so we've talked about the tolling agreement, and we can continue on then. We've got a little bit more regarding that here. Let's see, defendants are arguing that the non-signatory signatory defendants are not bound by the agreement. And the court's saying, nope, that's not going to work. And then they're saying that the AG's office is stopped from asserting the agreement binds everybody because of this legal theory. And this is the legal theory. And the judge said, nope, that's not going to work either. So they're really trying to get this agreement tossed out. But every argument they raise, the court's signing the law to them and saying, no, it doesn't work. So here's another piece. They're trying to say estoppel again should be applied, and the judge is saying no. The defendant's argument that the revocable trust is not bound by the tolling agreement falls flat. In his deposition, Donald Trump affirmed under oath that the assets of the Trump Organization are held in the revocable trust, for which he's the sole donor and beneficiary. Donald Trump also affirmed that at the time the trust was formed, he was the sole trustee and remained the sole trustee until 2017, when the defendants, Alan Weisselberg and Donald Trump Jr., became the sole trustees. As every beneficiary, donor, and trustee of the revocable trust is a defendant bound by the tolling agreement, and as the trust is unquestionably a parent of the Trump Organization, so too does the tolling agreement bind the revocable trust. So just over and over and over again, the tolling agreement is binding. So it is legitimate, and so too bad. That's basically what he's saying here. So here's the defense next piece. They pull in the New York Estates Power and Trust Law, saying that only a trustee can be bound in a trust to an agreement. And the judge is saying that's incorrect also. So can the judge now say during trial they can't use those defenses? Yes, he can. He can. And if they continue to go forward, he can have sanctions. Yeah, and again, because it's a bench trial, he can really limit what needs to be limited without having to go through all of the extra steps that you'd have to go through if it was a jury trial. So again, they're saying this agreement's not good because of case law, and the judge is saying your case law's bad, and then the judge is saying the agreement was mutually agreed upon, so you're going to just have to deal with it. So that's the tolling argument. Oh, that's probably a little bit, this quick and dirty version. All right, statute of limitations. So let's talk a little bit more about that. As a general rule, statute of limitations start running when a claim accrues. That is, when it can be sued upon. In arguing that the AG's causes of action are untimely, defendants incorrectly assert that the statute of limitations starts running on the date the parties entered into the subject agreements or when the loans closed. However, the First Department did not use the word closed. It used the word completed. Obviously, the transactions were not completed, while the defendants were still obligated to and did annually submit current SFCs to comply with the terms of the loan agreements. So again, they're just saying this is the next argument and it's non-availing. So nope, it's not going to work. The timing on it is fine according to the tolling agreement, and your arguments are insufficient. So business conduct falls outside the statute of limitations when all subsequent aspects of fraudulent conduct also fall outside the statute, no matter how inextricably intertwined. All right, so also going on to say we just need to look to the plain language of the statute in order to figure out what the law is. And continuing on, the AG's office is not challenging the loans, the closings, or the disbursements. It's challenging the defendant's submission of financial documents containing false and misleading information. And again, this speaks to this idea that nobody got hurt. They're not saying we're not here because of the loans or what happened. We're here because you actually put false information into documents, and that's against the law. All right, so he's clarifying that even a little bit more. All right, I think my tripod's moving again, everybody. Hold on, let me get it sorted again. One more time. I'm going to have to stabilize my desk here. Oh my gosh, I just don't know. I'm not as savvy with this stuff as I should be. There we go. How's that? Are we back in frame again, everybody? Let me just double check. I want to make sure we're still in frame. Oh my gosh. Yes. Okay. Thank you. Thank you. Thank you. Sorry about that. I just keep bumping it. I'll have to get a better chair maybe. All right. All right. So we've gone through the tolling issue. Let's talk about materiality. That's the next argument of the defendants have at this point. So it's settled that a standalone cause of action under Executive Law 6312 does not require a demonstration of materiality, but merely that an act has the capacity or tendency to deceive or creates an atmosphere conducive to fraud. Now, this is specific again to the first count. Remember, counts 2 through 7 are still being argued in court, but he's referring to specifically count 1 in this case. Again, he's saying the appellate court has already said that there can be liability. Defendants are arguing that they weren't materially misleading, basically saying that there is no such thing as an objective value. A substantial difference between valuation of the SOFCs and appraisals per se is not evidence of inflated value. There's nothing of improper about using fixed assets valuations opposed to using the current market valuations approach. And 4, it was proper to include internally developed intangibles such as the brand premium used in the valuation of President Trump's golf clubs in personal financial statements. So this is really where they're starting to say, our numbers were fine. That seems to be the defense's strategy. Our numbers were fine. You know, it's not our fault if you people didn't understand where our numbers came from. The judge is not impressed. Thus, defendants essentially argue that the value is inherently subjective, that because internal brand valuations are in the eye of the beholder, here, Donald Trump apparently is the eye of the beholder, they cannot be overvalued. Defendants argue that no bank or underwriter would have reasonably been materially misled by the alleged misstatements or omissions in the SOFCs and other information the defendants included. Yep. So the defendants made available to their counterparties because no sophisticated counterparty would have considered the SOFCs and other information provided by the defendants alone as material to the extent of credit or set an interest rate or issue an insurance policy or price a risk without doing their own due diligence. So this is what he's saying. He's saying, you know what? They looked into it themselves. And so they wouldn't have given us the loans if they had thought there was a problem. And so let's see what the judge has to say about that. Accepting the defendant's premise would require ignoring decades of controlling authority, holding that financial statements and real property valuations are to be judged objectively, not subjectively. So the judge is not impressed. Yes, giving you Ava. Oh, Ava, you're so funny. All right. Keep moving on. We're moving on here. Keep this show going. Moreover, courts have long found that generally it is the market value which provides the most reliable valuation for assessment purposes. It seems like a real estate developer would know that, right? I mean, it just seems like these are just basic legal principles. Further, the defendant's assertion, the discrepancies between their valuations and the AG's are immaterial is nonsense. Defendants have failed to identify any authority for the notion that discrepancies of the magnitude demonstrated here could be considered immaterial. So, judge is not impressed at all. So, that takes us then to his holding on the 2nd through the 7th causes of action, which is what we're in court for right now. The 2nd, 3rd, 4th, 5th, 6th, and 7th causes of action allege violations of Executive Law 6312 based on underlying violations of New York penal law prohibiting falsification of business records. That's 1 and 2, or 2 and 3. Issuance of false financial statements and insurance frauds. And then we've got also the conspiracy to commit each of those acts too. So that's where we get all of the counts from. After that, he goes through and breaks down which elements are involved. Now, accordingly, unlike a standalone cause of action under Executive Law 6312, the second through seventh causes of action require demonstrating some component of intent and materiality. So this is why we're in trial, all right? Because we need some kind of intent and some kind of materiality to be shown. And he's citing the People v. Alamo Rent-A-Car case here. As in all other situations requiring mens rea, or in civil court we call it scienter. However, petitioners may prove by reference to facts and circumstances surrounding the case that respondents knew that their conduct was unlawful. Moreover, petitioners need not prove respondents acted with an evil motive, a bad purpose, or corrupt design. So that level of intent is needed, and he's just saying some minimal level of intent. So he's claiming here the AG has demonstrated that there remain, at the very least, disputed issues of fact as to whether defendants violated these statutes intentionally and materially. Thus, there are issues of fact as to causes of actions 2 through 7 that require a trial. All right? So there we go. There are questions left to be answered by a fact finder. In this case, this judge, as a bench trial, is our fact finder rather than a jury. Accordingly, defendant's motion for summary judgment dismissing every cause of action is denied in its entirety. The AG's motion for partial summary judgment on its first cause of action. Oh, yay. Oh, thank you, everybody. Oh, that's so kind. Oh, hydrate. Yes, need to hydrate. One moment, please. Oh, my goodness. Whew, okay. Yes, thank you so much, everybody. What kind of tea are we drinking? It's rose orange tea. So with a little bit of honey. So it's it's drinkable. Oh, all right. So we've got the partial summary for summary judgment here from the AG's office. The trolls are from the FYP. Okay. Yeah, we just keep an eye out and just good for the throat. I agree. All right. Yes, mods, you are doing fantastic tonight. I'm so thankful. So very thankful for your hard work. All right. Summary judgment burden on standalone Executive Law 6312 cause of action. So this is just for cause number 1. As this court noted ad nauseum, Executive Law 6312 authorizes the Attorney General to bring special proceedings against any person or business that engages in repeated or persistent fraudulent or illegal conduct, while broadly construing the definition of fraud so as to include acts characterized as dishonest or misleading and eliminating the necessity for proof of intent to defraud. So this intent element is not needed for the first count. So that's why he was able to decide this case. Yes, ad nauseum. Ad nauseum. Is it Latin? I don't know. Yes, this judge is a bit quirky. He's a bit different. But I can appreciate that. All right. So let's see what the law is. The AG's office only needs to approve 2 things here. 1, that the SFCs were false and misleading, and 2, the defendants repeatedly or persistently use the SFCs to transact business. Those are the only 2 things that the AG's office has to prove. And so that's why he's able to come in with this motion for summary judgment and make his decision here. So let's look at his analysis. And this will give us his background into that. So this instant action is essentially a documents case. The detailed infra, the documents here, clearly contain fraudulent valuations that defendants used in business, satisfying the AG's burden to establish liability as a matter of law against defendants. Defendants respond that the documents do not say what they say, that there is no such thing as objective value, and that essentially the court should not believe its own eyes. And then this bumps us down to this very famous footnote now. As Chico Marx playing Ciccolini says to Margaret Dumont playing Miss Gloria Teasdale, in duck soup. Well, who are you going to believe, me or your own eyes? All right, so there we go. Citing the Marx Brothers. Why not? Why not? The defenses Donald Trump attempts to articulate in his sworn deposition are wholly without basis in law or fact. He claims the values of the property have gone up in the years since the SFCs were submitted. Then the numbers were not inflated at the time. Because you take the 2014 statement, if something is much more valuable now, or I guess we'll have to pick a date, which was a little short of now, but if something is much more valuable now, then the number that I have down here is a low number. He also seems to imply that the numbers cannot be inflated because he could find a buyer from Saudi Arabia to pay any price he suggests. Oh, it's not the best supporting evidence. This statement may suggest influence buying more than savvy investing. True. All right, so judge is not impressed with that. So let's start talking about his different pieces of property here. And I'll just be kind of hitting the highlights of these properties. The first is the Trump Tower triplex. The first bit is that it has been assessed at 10,996 square feet, but he was claiming it was 30,000 square feet. The reason why this makes a difference is because it caused an overvaluation between 114 to $207 million. So by inflating the square footage, we inflated the amount of value here, and it's pretty significant. Now, the defendants are suggesting that the calculation of square footage is a subjective process that could lead to differing results or opinions based on the method employed. The judge is saying good faith measurements could vary by as much as 10 to 20%, but not 200%. So the argument is not persuasive. Yeah, it's a lot. That's quite a lot of overestimation. So 200% is pretty significant. And now after each one of the real estate bits, the judge includes a statement supporting his motion or supporting the state's motion here. So the AG unquestionably satisfies its two-pronged burden, demonstrating the SFCs from 2012 to 2016 calculated the value of the triplex based on false and misleading square footage, and that some of the defendants repeatedly and persistently used the SFCs to transact business. So let me pause here. All right, this question of the statute of limitations that he brought up. So if what he's claiming is you can only use numbers from 2014 to 2016, again, we don't have confirmation, you still have 2 years worth of bad information about the size. So it's not going to have a negative effect necessarily on the case here. All right, let's get into the Seven Springs estates. So we have here fair market value of $700,000. And here, fair market value for all 24 lots was $30 million. So that's pretty significant. The $30 million here, and then we also reported the value at $261. So what they're saying here is the numbers are not numbering. All right. So July of 2014, the range of value came out at determine the fair market value at 30 million, right? So that's July of 2014. And then notwithstanding receiving market values from professional appraisals in 2014, the valuing was at 30 million, and he reported the value at $261 million for 2012, 13, and 14. A value to be $291 million. So that's pretty significant difference, right? Is it $30 million or is it $291 million? We're not fudging just a little bit here. That's pretty significant. And again, for the Seven Springs estate, he's saying, given the defendant's benefit of the $56.6 million figure as of December 1st, the value submitted by Donald Trump's 2014, again, that's within the scope of the numbers, was inflated by over 400%. Accordingly, the AG demonstrated liability for the false 2014 statement for fraudulently inflating the value of Seven Springs. Yeah, that's a lot. That's a pretty big difference. All right, so next we've got Trump Park Avenue. Let's take a look at that. Here we've got 2010 appraisal at $750,000 and a 2020 appraisal valued the 6 units at $22 million or $3 million per unit. Notwithstanding for the years of 2014 to 2021, they submitted a value of these rent-restricted units between as much as 700% in 2014 and 64% in 2021. So we have an inflated value, again, of 700% in 2014 and 64% in 2021. All right, so that's a pretty big inflated amount. Again, we're not just rounding up. I mean, I round up all the time, but I don't round up by millions. Any of us ever need, I hope we all get one that cares even. Oh, that's so sweet of you to say. I do care. I do care. I think it's so important that people understand this stuff. I think that's really great. All right, so here's his holding then on that particular property. However, the SFCs are required to state current values, not someday maybe values. At the time defendants provided the subject SFCs to the third parties, they unquestionably falsely inflated the value of the units based on a false premise that they were unrestricted. So we had rent restriction going on here. Next, we've got 40 Wall Street. Trump Organization, through the defendant, owns a ground lease of 40 Wall Street, pays ground rent to the landowner. 2010, we had, 2010, 2012, valuations between 200 and 220 million. And then later on, the Trump Organization's interest in the property was listed at $524.7 million and $527.2 million, an overvaluation of more than $300 million each year. So that's a lot. $300 million. It's almost $500 million. What are these people doing? Like, these numbers mean nothing to me. Other than the fact that they're incorrect. Oh, thank you. Yeah, $300 million each year. I mean, and you're trying to say like banks that's not going to be a significant difference? I don't know. All right, 2015, once again, appraised the property at $540 million. And in 2015, they listed the value at $735.4 million. Again, I mean, and this was in 2015. So we had 540 versus 735. Now bump down here to this end note. An email exchange dated August 4th of 2014 between Wesselberg and his son, a latter Capital employee, discusses the 2015 $540 million appraisal. Notwithstanding direct knowledge of it, the 2015 SFC valued Wall Street at nearly $200 million more. So we've got huge inconsistencies. His calculator's broken. Yeah, I don't even. How do you just, oh my gosh. I just don't know. All right. And so he's holding here, even giving the defendants the benefit of the $56.6 million figure as of December 1st. The value submitted on Donald Trump's 2014 SFC was inflated by over 400%. Accordingly, the AG has demonstrated liability for the false 2014 SFC for fraudulently inflating the value of Seven Springs. Yeah, I mean, again, 400%. That's a lot. Yeah, his brand calculator. I don't know who made his brand calculator, but they need to readjust the settings. Off to bed. Oh, good night, Deborah. Thanks for coming by. As always, it's wonderful to see you. Thank you so much for your hard work. I'm very thankful. All right, here we go. So, Trump Park Avenue. Let's get into that. Residential building, right? So 2011, 12 of the unsold condominiums were subject to rent restrictions. So let's bump down. 2010, we had 12 units at $750,000. Let's see, 2020, an appraisal performed by Frank valued them at $22 million. Notwithstanding 2014 to 21, they submitted the SFC that valued the rent restriction, inflating the value of each unit as much as 700% in 2014 and 64% in 2021. 700% inflation. All right. So, claiming this rent stabilization wasn't an issue because they were valued at what they could be if they didn't have rent stabilization. The judge was not impressed by that. Whoops. I've gone backwards. Sorry, my pages were out of order. We're back. We're back in order again. So the defendant's argument, again, too many times in many legal proceedings and in painstaking details, the claim is based on fraudulent activity. So disgorgement may be available as an equitable remedy. I'm confused where these values stated and posting the properties as collateral for a loan. Right. So the SFC. All right. So let's take a step back. Let's go back. The SFC, we'll just use 40 Wall Street as an example. Okay. So he's stating in his financial statements this over amount of 700% or whatever it is. Let's actually use the numbers here. Right. So he overestimated by $300 million. So when you fill out your paperwork and all of the things that you need to fill out in order to get loans, in order to get insurance, in order to put your value assessment, you swear the information that you say is truthful, right? So he was putting in numbers that were off by, 300% or $300 million each year. So the documents he was filling out that he was claiming were truthful were not truthful. That's the violation of the law. Now, whether or not this negatively affected the bank, that doesn't need to be proven. The crime itself, the tort, the civil tort is the fact that the information on the paperwork was false and that he knew it was false. That's what the tort is. It can be criminal. It certainly could be criminal, but at this point they have only filed it as civil, as fraudulent activity being perpetuated repeatedly in New York. That's the code section that they're using. So could it be criminal? Yes. I don't know what the statute of limitations is for filing a criminal suit for this kind of a situation, but, fraud is also criminal. So what we have here is a twofer where you've got a civil road that they're going down here, and then they could potentially go down the criminal road as well. But the false information on the documents is what he's being charged with or being sued for, is the repeated false information on the documents. Could be prosecuted later. Exactly. Yep. So that information was used to get various benefits or reductions depending on the situation. And that's what Cohen was testifying to. And so that's what prompted the investigation. Did they report correctly? I think that's already been established. The judge has said the numbers, the assessment numbers are what they are, and there's no changing those numbers. Going for a RICO in New York once this is settled could be. Absolutely could be. All millionaires do the same thing. That's true. But I think, one of the biggest pieces here is that we've got this huge bright light shining on this particular defendant. And this particular millionaire is, under a tremendous amount of scrutiny. And, because he was president of the United States of America, and he inflated his wealth by like 700%. On documents. Like he lied on documents allegedly here, although this judge said he did. That's why the motion was granted. But he lied on documents. And he's like, he was a president. Like, what's going on here, right? Just to me, it seems like, can you even imagine what would happen if Bill Clinton had filled out financial statements that were inflated by 700%? I mean, what would happen to Bill Clinton, right? Or what would happen to what would have happened to Nixon if they had found he filled out paperwork that had inflated numbers? I mean, Nixon would have gone down in a flame. He would have been on fire, or W. Bush. I mean, it doesn't matter. Pick who you want. Any president who is found to have falsified financial documents, that's pretty significant. Yeah, Obama. I mean, whomever. Yeah, Obama, whatever. Pick your president. Pick your president of choice, and imagine them filling out financial records regarding real estate and inflating the value of their assets by 700%. Imagine that. Yeah, I mean, to me, it's still shocking. It's still shocking that, he was in charge of, this entire country as the executive branch. And yet, in his own personal documents, he falsified information and he knew it was wrong. He wore a tan suit. He did. He did. So, I think it's worth noting that, like, oh, well, the banks didn't get hurt. Nobody got hurt here. We still have a former president lying the entire time he was in office about his assets and after he got out of office, like on papers, like he's signing paperwork knowing the information is false. And that's what he's being called out for. Now, whatever the accountability is for that, I don't know. But I mean, it's again, this moment of saying he signed the documents and, I mean, it's kind of a big deal. Taxpayers who paid their taxes get ripped off. Well, yeah. I mean, again, it's not, I don't know. I just think about those, maybe people don't remember when Martha Stewart got dinged with her white collar crime because there was some insider trading questions going on. I mean, again, she was doing what every other single person did, but she got dinged. But that woman, she was like, I did it. I'm going to prison. Went, served her time, came back out and was like, I'm sorry. You know what I mean? Like, if we're dealing with white collar crime, you got to own up to that stuff and take care of business. But I don't know. That's my tangent for a moment here. Yeah, you can't lie in the forms. You can't lie on the forms, Yeah, she went in like a boss. She was like, I got to sort this out. Yeah, I mean, she just owned up to it. She's like, fine, you're going to call me out and nobody else? Fine, whatever. Just take care of it. So I have a hard time having too much sympathy because it's like, dude, this is the highest job in the country. Snoop Dogg. I know Snoop Dogg was the best. All right. I digress with the Martha Stewart's tangent, but I'm just saying, white collar crime, it's like a thing, It's a thing. People do that. Yes, exactly. We forgive her. Yeah, I remember she came out with that knitted poncho and I was like, you're the most amazing person I've ever seen in my life. Coming out of prison with a knitted poncho. Good for you. All right. I digress. All right, let's keep moving on. Mar-a-Lago. Let's get into Mar-a-Lago. Oh, yeah, I know. She's so freaking amazing. All right, Mar-a-Lago. So we've got, and again, why would Mar-a-Lago be important? This is a New York situation. It's because he used it as an asset on his financial filings. So that's where it comes together. Now we've got, this judge goes into kind of some background into Mar-a-Lago and how it was supposed to be a club. And he had said that it was always going to be a club. This was something that was agreed upon. So Trump's NFC for 2011 to 2021 puts Mar-a-Lago at $426 million. Meanwhile, an assessment from the Palm Beach County assessor appraised the market value between $18 to $27 million. So, this is probably the worst inflation of all of them, really, because we have $18 million here. That's a far cry from $426 million. You know what I'm saying? And 27 versus $612 million. That's a pretty significant inflation amount. And if you put an asset down on your